Pipelines are always going to be divisive. There are those in favor of the economic potential, others against because of environmental concerns, and many other challenges in between. Some Indigenous groups in British Columbia, like the BC Coastal First Nation, say they will do everything in their power to stop this project. Let's go to Calgary. Jeremy Barretto is standing by. He's an expert on regulatory and Indigenous law. Good to see you. Thanks for taking the time for us.
Good to see you too.
All right, so what does this mean when you hear those arguments from the Coastal First Nations trying to challenge this already? And how could this potentially play out? As you know very well, as per the Constitution, the federal government does have ultimate jurisdiction over the pipeline, on paper anyway, but of course in the real world, in practice, it gets a lot more complicated.
Absolutely. And I view the agreement yesterday between Ottawa and Alberta as a starting line as opposed to a finish line. It indicates alignment between the federal government and the province of Alberta on pipelines, energy, and certain other climate policies. But definitely more work needs to be done. More agreements need to be made. In particular, more engagement is required with the province of BC and the coastal First Nations to understand their concerns and to see what mitigations are possible. At the end of the day, pipelines are built in this country with a series of gives and takes. You may not reach a consensus from all affected parties, but it's important for governments and proponents to maximize consensus and try to, reach the maximum amount of support possible.
I wonder, so you're seeming to indicate that there could be some sort of room for negotiation. I just want to read from the press release from the Coastal First Nations where they say, there's no technology that can clean up an oil spill. We have zero interest in co-ownership or economic benefits. This is not going to happen. This MOU does nothing to improve the chances of a pipeline as well. Again, reading that would seem to be no, no, and no.
Absolutely. And I would look to, the MOU may not address concerns, and there's definitely significant concerns and opposition at this point from the Coastal First Nations. But hopefully this is a start of engagement. I'd also point out that Premier Eby's statements weren't as clear in that Premier Eby was pointing to the lack of a proponent and the lack of certain other planning steps. But there could be a series of gives and takes with BC. And the final point I'll make is that there are Indigenous nations across a potential new pipeline to the West Coast, and there's a diversity of opinions within Indigenous nations, just like there's a diversity of opinions between the province of Alberta and BC, and even within the federal Liberal Party these days. So I think we'll see a number of nations as you move east through Alberta and through BC into Alberta that may support or want to take advantage of co-ownership, but there definitely remains significant work to be done with the Coastal First Nations.
You raise a great point. There are some First Nations that are in favor. There are some that are against. Question for you, what sort of legal grounds would First Nations that are against this project actually have if the ultimate authority lies with the federal government in the Constitution?
The federal government has a constitutional duty to consult and, if necessary, accommodate the affected Indigenous nations that are potentially adversely affected by the decision on a new major pipeline. So typically, if we look back to the Trans Mountain Pipeline or the Northern Gateway Pipeline, which was not constructed, those legal challenges were based in large part on the sufficiency of Indigenous consultation. And I think what I would look to next is significant efforts that would be required by the province of Alberta, the federal government, and any future project proponent to engage in deep and meaningful consultation on pipeline proposals, understanding that there's no specific route picked yet. So there's room here to shape any pipeline proposal to the West Coast to minimize concerns. And the requirement is not necessarily in all cases consent. There's not necessarily a veto from any one party, but there's a requirement for meaningful consultation, if necessary, accommodation regarding the project in order for it to withstand challenges in the courts.
Well, that brings me to my next question, and the wording that's very interesting. You just used it, this idea of a duty to consult. But what does that mean? Because it doesn't give any First Nation a veto over a pipeline project. It's about consultations, taking their views into consideration. But ultimately, they can't veto a project, correct?
The The duty to consult requires a process, and governments that are making decisions hearing concerns from affected Indigenous nations, and if those concerns affect Indigenous rights or titles, accommodating them through changes to the project or other types of benefits. But I would point to previous pipelines where there have been concerns from Indigenous nations, and they have been accommodated through, in some cases, rerouting. I would point to the Coldwater Indian Band, the Trans Mountain Expansion Project, which secured a major change to the route near their reserve in order to address some concerns. But there isn't, in all cases, absolute consent required. If the consultation was adequate and meaningful and concerns were reasonably mitigated, there's not a need for 100% consensus. But I would encourage the federal and Alberta governments, as well as any project proponent, to maximize consensus, to try to address any reasonable concern received, because that's the best way to ensure that the any pipeline approval is defendable in court.
Last question. Do you think that there is a chance this pipeline could end up, tied up in endless legal battles and or lead to protests and demonstrations trying to block this physically from happening?
That is a risk. And we've seen with recent pipeline projects, Northern Gateway, Trans Mountain, and the Coastal Gas Pipeline, there has been a lot of debate and in some cases protests and blockades. I think to maximize agreement, the agreement yesterday between Ottawa and Alberta should be the start, and many more agreements would be required, looking to the province of BC, looking to affect Indigenous nations, to hopefully build the consensus for a pipeline if that's what the affected governments want to do. But in the absence of agreement and meaningful engagement, I think you'll see conflict. And that's the history of these pipeline projects, where we'll see years of regulatory and court process. And even with the government's federal fast-tracking legislation, that won't address court challenges if they come. And it's incumbent upon governments to get this right now, to do the work, to get out to the affected communities, to mitigate concerns and maximize consensus to avoid those future potential challenges.
Jeremy Barretto joining us from Calgary. He is an Indigenous, a regulatory law expert. Hey, good to see you. Great conversation. Thanks for explaining all that to us.
Thank you, Todd.